All right, I think it's slowing down. Again, my name is Sipra Boyd, and I'm an attorney, a shareholder with Roberts, Markell, Weinberg, Butler, Haley. Happy to see so many people joining on. I see lots of names I recognize. We're going to start today by talking about the exciting bills that have been filed in the 2025 legislative session. This is just a real general overview of the bills. I'm gonna, on the slides, you'll see kind of just information about the representatives or the legislators that have are sponsoring the bill, kind of the status of the bill, the codes that the bills impact, whether it's single family associations or condo associations or both. And again, just kind of a high level introduction. There's at least 40 slides, I think, which I think we're talking about most of the bills that were filed that impact associations, but there are several others that kind of peripherally impact associations that I've left out. But we're just going to track them and see how the session continues. All right, again, thank you all so much for joining us. We are involved, the firm is involved at the legislative level. I think I saw or was able to hang out with some of you at Rally Day at the Capitol a couple of weeks ago, and that's always a fun event to try and go talk to our legislators and explain why some of these bills maybe aren't as great as they might seem. Quick disclaimer, the information that we're presenting today is based on the law as it exists today. Obviously, this is all for informational purposes and it doesn't constitute legal advice. If you have any questions or specific issues that you need legal advice on, we would encourage you to contact the association's lawyer for those. Real quick agenda, I'm really just gonna talk quickly about the key dates, and then I'm gonna dive into the, like I said, 40 or so bills that we're going to talk about today. So in terms of key dates, Monday, November 11th of 2024 is the first day that the legislators can file bills. And this is the 89th legislative session. As you know, the Texas legislature only meets every other year. Tuesday, January 14th is when the legislature convenes at noon. And then Friday, March 14th is the 60-day bill filing deadline, which we just passed last Friday. So after last Friday, no more bills can be filed. That doesn't mean that the bills that have been filed can't somehow be amended and added on to, and in fact, what we've seen in the past substantially changed. So that does happen, but no new bill files. Monday, June 2nd is Sine Die. That's considered the last day of regular session. Sunday, June 22nd of 2025 is the last day the governor can sign or veto bills. And then Monday, September 1st of 2025 is typically the effective date of most of the bills, unless the bill specifically otherwise states that there's a sooner effective date, which some of these do have that. All right, so we're going to dig in because there's, like I said, a lot to talk about. House Bill 294 and Senate Bill 141. What you will see on most of these slides is a House bill number and a Senate bill number, and that just means that the bill has been filed both in the House and the Senate, that there's a companion bill. And I think it's just kind of a race to see which one gets to committee or which one is heard and moved through the legislative process quicker. And I don't really know the tricks of how that all happens, but apparently there's some benefit in filing two different types of bills. This one is our famous chicken bill that we call, but it doesn't involve just chickens. It also involves vegetables or what we refer to as using your property for like a cottage type industry purpose, and then the rabbit bill. So this one we've seen over and over in the past legislative sessions. It's really had trouble for a variety of reasons, which I guess, I'll refrain from kind of publicly giving my opinion, but I know that this one is a problematic one for us, because it basically says that the association can't enforce or adopt a provision that restricts the growing of fruits and vegetables or the raising or keeping of 6 or fewer fowl or 6 or fewer adult rabbits. There are some good things about the bill, if you can consider them good, but we can impose reasonable requirements related to the gardening. There's also some limitations, I guess, related to the type of fowl. We can prohibit a rooster. There's all sorts of restrictions about kind of the size of the housing for each one of these types of animals. And so there are some limitations. This is a similar bill that, like I said, we've seen in legislative sessions in the past that have not passed. We are concerned that this might have more traction this year because of the price of eggs, and just things that we're seeing that I think would potentially put this on more people's radar, as a result of the pandemic. So it's just been a long time in the making, but here it is again, and we'll see what happens. House Bill 336 and Senate Bill 690. This one, it's similar to probably 3 or 4 other bills that you'll hear me talk about, but essentially it provides for it gives the association a POA authority to enter into a contract for services with sheriffs and constables. This particular version of the bill impacts counties with a population of more than 1 million. The other bills that you'll see that I talk about have different population requirements. Not exactly sure, I guess, what the purpose is of that, but this one does impact HOAs and POAs. I forgot to mention, I guess I'll refer to them as condos and single family. The chicken bill, while in Chapter 202 of the Texas Property Code, impacts only single family residential homes or lots. 202, the applicability section of that chapter actually applies to single family lots and condos, but the bill actually has a carve out regarding single family lots. This one that I was just referring to applies to both condos and single family. House Bill 359, House Bill 517, and House Bill 5387. Again, you'll see the various authors of the bills and the status of the bills. This one also affects section or chapter 202 of the property code. This one applies or restricts an association's ability to assess fines for violations of any restrictions related to maintaining grass, essentially. So it will prohibit fines for violations that require an owner to maintain green vegetation or this discoloring or brown vegetation of turf. The water restrictions or this prohibition only applies when there are water restrictions that are imposed by either the municipality, the water utility, or some other type of wholesale or retail water supplier. And this prohibition against the association's ability to assess fines applies even for a reasonable period of time after the restriction or the water restriction is lifted. House Bill 431, really minor revision to the solar energy devices statute. It adds the definition, it adds solar roof tile to the definition of a solar energy device. So nothing major, but apparently there are different types of solar energy devices and they want to make sure that they've captured all of them. House Bill 621, this one is, I guess, very similar to probably 2 or 3 other bills that you'll see that I'll talk about. And this one is maybe in the most favorable form of the bill that we've seen. But essentially, it says that the association can't enforce or prohibit governmental officials or candidates that are qualified for appropriate elections from meeting or addressing owners, residents, and other invitees in POA common areas. And so this is kind of the general right to assembly, freedom of speech, right to association type protections that we've seen quite a bit in the past few years that impact HOAs. The good thing about this version of, or this bill in particular, is that the association does have some restrictions or regulations that it can impose on these gatherings. It can require some type of a rental fee or deposit, a reservation agreement or a rental agreement. It can limit the occupancy of the number of people that attend the gathering, establish minimum hours, and then specify which common areas are available for these types of gatherings. As you'll see in the other bills, they're very general. These other bills generally say that the association can't prohibit anyone from gathering anywhere at any time for the purposes of political speech, and there's really no ability for the association to limit those gatherings. So this one, while still we think really creates some difficult, I guess, oversight for associations is what I'll call it, because we're now burdened with trying to regulate, who and when and for how long and what time political organizations or candidates want to use our common areas. It does allow us a little bit of freedom. House Bill 648 has to do with the installation or use of a clothesline. So, like all other bills, I'm sure there's a homeowner that got into a beef with their association about a clothesline, but this is where bad facts or bad actions by associations potentially create bad law. This one actually says that we can't prohibit the association from the association can't prohibit an owner from displaying a clothesline. There are some restrictions. It has to, if the clothesline somehow threatens public safety, it can't be located on property owned or maintained by the association or a common area. It does limit whether or not it's visible above the fence line. And it requires approval by the HOA for any clotheslines that are either established in the side or patio yard, so ones that are visible. So there are some good, I guess, limitations in this one, but this essentially would allow people to have clotheslines maintained on their property. House Bill 918, this one also is similar and one of the more general bills that talks about peaceful assembly, and this one also impacts single family associations as well as condo associations. It's in chapter 202 of the property code, but again, this one basically says that the association can't prohibit or restrict anyone, owners, residents, invitees, guests, from assembling in a POA common area. These people can invite guest speakers, including public officials and candidates for office without any type of prior approval from the association. We really can't restrict or regulate the content of the owner or the resident's speech. And there's really no other restrictions in this bill except for unless the conduct or the speech violates law, threatens public safety, or is patently offensive. And so a little bit of a carve out, but really the association has no control over how, when, where these public gatherings can happen in HOA, in the HOA property. Again, this was similar to one that was filed in 2023, but it didn't make it out of committee. So it's another one to watch. House Bill 1087. This one is a little bit concerning for us in the industry. It basically requires a special election or some type of an election if there is a vacancy that's created on the board. Typically, the process that most associations follow, that also is in the Business Organizations Code. It's, has been in the Property Code for quite some time. It's usually in all of your governing documents, is when there's a vacancy created, the remaining board members can appoint to fill the vacancy for the remainder of the term. This one would require an election. The election would have to follow the similar protocol that other regular elections follow. So that means you would have to solicit candidates for the potential position. You would have to hold a meeting, which, creates additional burdens for associations to send out notices and agendas and ballots. And then the quirky part about this one is the board member that's elected in this election is then elected to serve until the next election. It's not even until for the term of the predecessor that resigned. So it could be that a board member resigns, 6 months left into their term ending, and we have to have an election in the middle of the year, and then 6 months later, when the term does actually end, there's another election for that candidate and possibly others that we would then have to have another election for. It's just kind of quirky and costly, possibly. House Bill 1133, this one's also an interesting one. The association, this has to do with essentially allowing owners to have swim lessons on their property. So it doesn't impact the association's pool, but it basically incentivizes homeowners to have some type of a swim lesson or use their property or pool for swim lessons. Now, there's there's some regulations on how the property can be used and what type of instructors that the owner has to use. And there are some other regulations, but in our minds, this is basically allowing a business use of the property. So it essentially says the association can't adopt or enforce a restriction requiring a certified swim instructor to essentially conduct swim lessons. The instruction can be contained in a rear yard that's not visible. There are some time limitations, only between 8 a.m. to 8 p.m. And there are some, I guess I'll say, occupancy limitations. So no more than 4 people having a lesson at any given time during that instruction period. I guess you could have 12 instruction periods between 8 a.m. and 8 p.m. But as you can imagine, that's a lot of people coming into the subdivision that probably don't live there. There are some requirements for the home that is having the lessons conducted. There has to be some type of access to a permanent restroom that's connected to water and sewer, and that restroom can either be located in the house garage or accessory building. I'm not sure that necessarily moves the needle on, making us feel better about the fact that there's a business being run, but there are some limitations. And this again is in Chapter 202, so it applies to single family and condos. House Bill 1246. This is another one that, again, is similar to the one I mentioned about giving associations the authority to enter into contracts with law enforcement. And this one doesn't have any population limitations, so this one's a more general bill, applies to both single family and condos. House Bill 1349 is the return of the bill that was vetoed by the governor in 2023, and that big splash of bills that were vetoed after the governor signed them. This one was a pretty good bill that we were really hoping would stay and would not be vetoed. So we're glad to see it back, and hopefully because it was signed by the governor, the last legislative session, it'll quickly run through the legislative process. But as a reminder, this one would require condominium associations to do what single family associations are all doing, which is to update their management certificates to include fees. It would require them to maintain some type of a publicly accessible website for their governing documents to be located and accessed. And then obviously it would require them to also file the management certificate with TREC, which I know that for some of the condo associations that we represent, they're already actually doing this as a result of the single family law. It does also address issues with perimeter fencing, which we really like. It's a kind of a cleanup bill as a result of the problems that we saw from the security measures bill a few years ago. It kind of prohibits or limits an owner's ability to put up front yard fencing if that limitation is already in the declaration. It also prevents fencing that would block some type of an easement or a sidewalk or something like that. So again, a cleanup bill that I think is beneficial for associations. And then it also addresses that the former ACC bill that essentially requires board members and ACC members to be separate and not serve in either capacity at the same time. I know that most of our associations have issues with volunteerism, and so it's hard to find 3 board members and 3 separate ACC members. And so this really provides the association with a carve out that says, as long as you've solicited candidates for the ACC and tried to fill those positions by people that are not board members, then a board member can serve in that capacity. So again, gives us a little bit of breathing room on that prior bill. House Bill 1432, this one really is a modification to something that's existed for a long time, legislation that, or a statute that's existed for a long time regarding drought resistant landscaping or water conserving turf. That legislation has been out there for a long time, and it amends the current bill, which is in chapter 202, and it's basically our xeriscaping bill. What this does, I think in the past, associations that want to promote xeriscaping but don't necessarily want 100% drought resistant landscaping or turf, they now have to allow 100%. So it basically just modifies that legislation that says we can't restrict or prohibit drought resistant landscaping in lieu of natural turf. So it does give homeowners the ability to, again, to put 100% non-natural turf in the yard. There's still requirements about plans being approved and a diagram that has to be submitted, but that plans don't have to be prepared by any type of a licensed architect or professional. House Bill 1486 applies to single family and condos. This is another chapter 202 provision, and this has to do with the particular flag that is on the screen. It's the one with the thin line that, it's my understanding, is the one that promotes or supports law enforcement. And essentially it would add this type of flag to the list of flags that are protected under that flag display legislation that also was amended a few years ago. But it would list this as one of the ones, including the U.S. flag, the state of Texas, and any branch of the military. House Bill 1812 This one's kind of an interesting one. It basically requires associations to maintain their common areas in accordance with the same provisions as owners are required to maintain them. I'm not entirely sure of the purpose, but I imagine the way that this got to the legislature is that some homeowner received a letter about their landscaping or their failure to maintain their lawn, and they live near or next to a common area that wasn't being maintained well by the association, so he doesn't feel like he should be treated differently than the association. So this puts some burdens on the association to maintain their own common areas. House Bill 1862, another one of the similar bills regarding law enforcement and the ability for the association to enter into contracts for services. This one has a population restriction and it bumps it up to 1.2 million. A lot of legislation that gets filed for whatever reason, and I think there's a reason, obviously, but it doesn't mention a particular county, the legislation can't mention the particular county. So the way that they get around that is by mentioning the population size of the city or the county that the bill impacts. Those are called bracketed bills. And so there's 3 or 4 versions of these with different population limits. House Bill 1926. This one is a good one, and I think it's really intended to just kind of clean up some issues that we've seen in the industry for our condos and our single family homes, to clarify when the associations can use electronic board meetings and electronic or virtual member meetings, as well as what types of voting mechanisms must be provided, because there's currently a statute that, in our opinion, is a little bit confusing about the association not having to provide more than one type of voting method, but it has to provide voting by proxy or absentee ballot, but it doesn't mention electronic ballots. Anyway, it's confusing, and I think if you've asked us for an opinion, we're kind of taking a conservative approach on what it typically means, but this would clean that up and make it really clear that associations, whether condo or single family, hopefully, again, if it passes, can have virtual meetings, board and member, and also can use the different types of voting methods that are offered. House Bill 2013, this is another chicken bill part 2, and this one's different, and this basically really has no limitations, but it says that an association can't restrict owners from keeping chickens as long as or if there's a municipal ordinance that authorizes the owners to keep chickens. And that's basically it. It's really a simple bill. So if your city allows chickens, then we have to allow chickens. Obviously, I think that one has some issues. I'm sure if the city has an ordinance allowing chickens, there's probably some limitations in it, but I'm guessing that the HOA's restrictions are going to be typically a little bit more restrictive, and so it would be nice to have a few more limitations, like the first chicken bill that I spoke about. House Bill 2082. This one really has to do with people that are involved in lobbying efforts, I guess, or campaigning efforts. And essentially, the association is prohibited from enforcing restrictions against door knocking, bell ringing, or the leaving of pamphlets or flyers, information for the purposes of getting people to get out and vote. And also for the purpose of communicating support or opposition to a particular candidate, political party, or political measure. This one's, again, very similar to the ones that we're seeing about associations not being able to restrict, peaceful assembly and other types of events. on association common area. And, to me, this is like essentially confirming that people are allowed to solicit in subdivisions, which is, I think, already a problem. But this does put some, or allows associations to put some limitations on the time, place, or manner in which any of this activity is allowed. So there are some limitations that we can put in place, but again, we can't restrict it completely. House Bill 2269 prohibits associations from requiring a property owner to plant or install grass or turf. And then this is weird, but the second part of that bill also says that we can't require an owner to maintain living grass. Again, I don't know what this is about, except for I want to be able to do whatever I want to do on my lot. And if the landscaping looks like crap, I guess you can't send me a letter for it. I don't really know. This one's a weird one. So again, it affects that chapter 202 that already talks about drought resistant landscaping or drought resistant turf. House Bill 2280. This one's an interesting one, and I guess it's, again, another fallout from prior legislation, which has existed now for a few legislative sessions, regarding an owner's, or I guess the association's, ability to restrict signs or political signs. Currently, the statute says, we have to allow political signs. There's some deadlines that are in the statute that say, no more than one sign per, I think it was, measure or candidate that's up for election. What this does is basically say that if a homeowner receives a letter that is in reference to an existing sign, and as long as the sign is allowed under the election code, is where this lives, then the property owner can file a lawsuit and obtain an injunction against the association for receiving that notice, and that if the court finds in favor of the owner, that the owner is entitled to reasonable attorney's fees if it prevails. And so I guess what's happening, I think that there's some confusion with the current election code. We think it's fairly clear about what types of signs and when they're permitted and the size, but it sounds like some homeowners have received letters because they may not be in compliance. And so again, bad facts make bad law. So we're seeing something that says, hey, if I get a notice and my sign's okay, we get to sue you for it. House Bill 2398. This one is a large bill, and it has lots of changes to Chapter 209, most of which we don't like. And I'll just kind of go by section by section. So it amends Section 209.0041, and it basically says that any dedicatory instruments, excluding declarations, can be amended by a majority vote of the owners. I guess it limits it and says if there's a higher percentage, then that higher percentage prevails. It also amends both 209.00592 and 00593, which have to do with voting and quorum. And it basically creates or establishes penalties for violations of those two statutes. So again, we're seeing, I think, especially after the last bill, we're seeing penalties added for violations by the association of a particular legislative statute. which is, I think, a problem. Obviously there was a bill a few years ago. There's a legislation currently, a statute that says that the association can be sued for a violation of the property code, or a board member can be sued. And so I don't really know why this is any different, but now explicitly they're asking for some explicit language in each one of these provisions. And then section 209.018, there, it has a problem in that it increases the standard of care, creates liability for board members as fiduciaries, which currently the law is that there's a reasonable standard of care for board members as long as you act in ordinary faith with good care. In good faith with ordinary care and in a manner that the board member believes to be in the best interest of the association, you're protected against potential liability. That higher standard of care, the one that's owed by Chapter 82 condos, that one of a fiduciary or a trustee, is really limited to Chapter 82 condos. And so this kind of expands that standard of care, which we find problematic. House Bill 2504, this is another one that's in response to prior legislation that capped the amount that an association can charge for resale certificates. It again says, hey guys, we're really capping this at $375 for resale certificates and $75 for any updates. But then it goes on to say you can't charge or add on any ticky-tacky fees for conducting an inspection or doing anything else that you might be charging for currently that is incurred as a result of information that you're providing on the resale certificate. So I've seen this where some associations are charging $375 for the resale certificate, but then they're adding a $200 inspection fee to go out and ensure that there's no pending violations to report on the resale certificate. So those are out the window, if this gets passed. House Bill 2630, there's a couple of these which are, I think, problematic, especially for our developer or development period associations. It changes the threshold for when a resident elected owner gets to be on the board. And obviously I say it's a problem because when a developer is creating the subdivision, the developer intends or wants to hold on to control for as long as it possibly can in order to complete the development of the community in the manner that I guess it sees fit. And so this kind of forces, we saw this a few years ago with at 75% or 10 years, 1/3 of the board members had to be elected. This is a little bit more substantive and sooner. This says one board member has to be elected within 120 days from the date 50% of the lots are sold to someone else besides a developer or builder. The 1/3 requirement for 75% is still there. So at 50%, one board member, and I don't, typically most developer boards are 3, but I guess if you have a 5-member board, it would still only be 1. And then if the declaration doesn't include a number of lots, then the transition to 1/3 was after or the 10th anniversary of the date of the recording of the declaration, and this reduces it to 5. So it really shrinks the development control period. House Bill 2828, which is an interesting one. It probably won't get much traction. It's only just been filed. It hasn't been referred to any committees, but it would basically say that an association is not required to accept a partial payment of any amount unless there's some type of a written agreement with the owner or payment plan. That's kind of the position that we've taken for many years based on probably a combined reading of a couple of the statutes that exist now, but this would make that clear. House Bill 2842 deals with white-tailed deer population. Apparently, I guess associations that have issues with the white-tailed population, when I guess the season for recreational hunting is not in effect. This just puts burdens on the association to provide notice outside of those recreational hunting seasons if it implements measures to control the white deer population. House Bill 3381 restricts a person from simultaneously serving as a presiding officer on a MUD board and an HOA board. So this one's an interesting one. It doesn't prohibit them as if they're just serving on both, but not a presiding officer position. But essentially, if you're a president of the MUD board, you can also be president of the HOA board. House Bill 3908. This one messes with the current chapter or section 209.006 regarding the notice required for fines and the time frame required for fines. And this is an interesting one because there's a 4-year statute of limitations for enforcement, and this to me kind of tinkers with that. But it basically says that a notice of restriction, a violation of restrictions, has to be provided no later than 180 days after the violation occurs, and a fine can't be assessed unless that notice goes out. So I think this is a tricky one, because if the association doesn't notice a violation, within the first 180 days, essentially it can't fine for it, because there's no way to send a notice after that time, and you have to send a notice before you can fine. So this one's a confusing one. I think it's, again, just trying to limit the association's ability to fine, obviously. Senate Bill 1935. This is a large one. And this one is related to some of the limitations to the development control period. This says that as long as the board is not elected by owners, again, during that development period, then any board meeting has to be within 10 miles of the subdivision. And then it also talks about the 1/3 of the board members must be an owner elected 120 days after a majority of the lots are sold. So again, reducing it from that 75% requirement down to the 1/3. And then it says a majority of the board members have to be elected at the 75% threshold. So it used to be 1/3 at 75%, and then at full turnover, the entire board. And this says at least 1/3 at 50%, and then a majority of the board members at 75%. This also puts some language in the statute regarding fines, and it basically says that your fine policy has to mention, or your fines have to be reasonable in the context of the nature and the frequency of the violation. And if you're allowed to kind of accumulate fines, there has to be some maximum amount. You can't just continue to fine, forever. And then the most worrisome one is that an assessment increases are capped at 5% unless there's a vote by the owners, a majority of the total. And so for a variety of reasons, that one's a problem. House Bill 4356 prohibits an association from enforcing or restricting an owner from displaying at least one sign that contains a political message. So this one's a little different than the one, the flag or the bill that allowed or protected the flag with the thin blue line that supports law enforcement. This one generally says you can have one sign with a political message. And I know I'm probably getting a lot of questions about this, but I think a sign is a sign. There's also lots of questions about what's a flag and what's a banner. I don't know that this really doesn't clarify any of that. It just says if there's some type of a political message, the sign has to be allowed. House Bill 4447. This one's a little bit of a problem. I say a little bit, I guess, facetiously. This one adds a requirement for an association to file any rules, regulations, policies with TREC, not later than the 7th day after filing a management certificate. And so, our policies already recorded in the real property records, but this one says we have to also file them with TREC. And the worst part is that there's a penalty that says that the association has to pay $1,000 as an administrative penalty for the first day that it violates this, and then $500 for each subsequent day. And then the other interesting part is if the association doesn't comply, is fined, somehow the association can't recoup the amount of this penalty by passing it on to the homeowner. So you can't increase your assessments as a result of these fines that you're having to pay for violating this provision. So I'm not sure where you get that money from. House Bill 4566. This one we don't really have a problem with. It just kind of lessens the burden of the requirement that a records request be sent by certified mail now, as long as it's sent by U.S. mail, email, hand delivery, or any other method, then it's a legitimate request, and then it just has to describe in sufficient detail the records that are being requested. Again, just trying to make it easier for owners to request records, which I know there's problems with that, but apparently, this has someone's ear because they're struggling to get records. This one's not a major one. This just requires, or gets away from a condo having to get a plat approved. It explicitly says a plat's not approved for a condo. House Bill 5011 is a terrible one that basically says if an owner is involved in a litigation matter or judicial action against the association, then the owner can withhold his or her assessments while the action is pending. If the association prevails, then the homeowner gets to pay his assessments. But if the owner prevails, then the association can't file a lawsuit to collect the assessments. It's very confusing, and this has lots of legal problems because there's some mandatory claims that have to be brought when there's pending actions, and it impacts our ability to collect assessments when a homeowner sues the association. So if you don't want to pay your assessments, just sue the association. House Bill 5225, this is another omnibus one that impacts lots of various sections of Chapter 209. I'm kind of coming to a close so that I can try to take some questions. I know there's a ton, but Section 209.0006 has to be about, is about fines, and it basically says that you have to add a language in your fine policy that says the association can't impose unreasonable fines. What the definition of unreasonable is, we're not certain. It also limits the ability for the association to increase assessments to a reasonable amount. Again, unreasonable is not defined, so we don't know what that means. If it is unreasonable, then there's a vote required by the members. There's also a new assessment policy, which is, I guess it's trying to comport with the fine policy, which had to list general categories of fining. And so this says you have to provide general categories of restrictive covenants for which the association levies assessments, a schedule of assessments for each category of common area maintenance or improvement, and then a schedule of fees for the use of amenities. Complicated. The POA can't levy an assessment for the maintenance or improvement of common area without a vote of the members. The association can't file a lien if the only purpose of the lien is to secure a minor fine. I don't think minor is defined. It removes a lot of the association's ability to control aesthetics through the ACC. So if the homeowner wants to paint their residence a particular color of their choice, and construct perimeter fencing, or improve landscaping, they don't have to get approval, and we can't restrict it. The one positive thing is that it does require an association to seek approval. I'm sorry, it requires an owner to seek approval, HOA approval, for a short-term rental, which is defined as a period of less than 30 days. Not sure why that's in there. Another one that, again, has to do with agreements with law enforcement for constables or sheriff's services, but this one is $3.3 million. Senate Bill 2783. This one's another one that protects the type of flag displays, as long as you're promoting an office, elected official, or political party. And this is the one I think I made a comment about political signs versus political flags and banners. And I think this is just saying if it's a flag, you can fly it like you would a sign. House Bill 5438 removes the association's ability to enforce limits on residential leasing for terms over 6 months, which is kind of a weird one. So I've had associations ask for short-term leasing policies or amendments that require no less than a year for the lease term, and so this statute says nope, you have to allow 6-month lease terms. And it also prevents occupancy limits that are in the lease policies or amendments. All right, so again, quite a bit of legislation. I'm going to try and see if there's some questions that I can quickly answer. We don't have a lot of information on, which one of these have lots of legs and are going to get adopted, but we're going to keep monitoring these like we do. We're going to keep providing updates. If you or your association is involved with TLAC, which is the legislative arm of CAI, you're going to get probably calls of service to call your legislators when any of these are going to be heard at committee, or sometimes when owners or business partners are being asked to come testify either in favor or opposition of any of these. So please pay attention to those alerts. All right, I'm going to try and go really quickly. House Bill 359, irrigation. Does this apply to permanent water restrictions in municipalities such as North Texas? Well, I don't know the answer to that. I mean, I think there was 3 types of different restrictions, water restrictions that were mentioned. And I guess if it's permanent, there might be an issue, but if it's one of those 3 authorities, then it applies. House Bill 621, can a gated community require a list of named attendees to grant entry? The bill doesn't speak to that, but I'm assuming if we can regulate some of this to a certain degree, then maybe we put that in some type of the reservation or rental agreement and see what happens. I don't think the bill talks about that. Can a policy be created to remove a member with a history of harassing board members, office staff, and committee members if their presence disrupts the meeting? Yeah, I mean, I really think that, at least in the first one that I spoke about, the association has more control over the political event that takes place. And so I would even say, regardless, if anything that is happening in your community is disruptive, I think, obviously law enforcement needs to be called as immediately as possible, because the association shouldn't be involved in enforcing potential criminal violations. Would House Bill 1087 apply to condos? I'm sorry, I don't remember I'll try to look at it while I'm I'm looking at these questions. I don't remember which one that is. And then Beth sent us a helpful link. I do remember, I should point out that the TLO website, the Texas Legislature Online website is fantastic. And maybe I'll ask Kyle to put the link in the chat, but that can track all the bills. You can put House bill, Senate bill, and the number, and it tells you the text of the bill, the analysis of the bill. It's very helpful. It tells you where in the committee process or the House and Senate process that it is. If it's gotten through either one of the houses, and it's really, really helpful information. So please use that. Does publicly accessible website mean for general public? That one's a good question, and I'm not sure anybody knows the answer to that. What we have routinely said is, if at all possible, you can maintain your governing documents on something that is publicly accessible, and then anything else that you want to limit as being behind some type of a password protected part of the website, or minutes of board meetings or notices or agendas or budgets or any of that. That's what our recommendation would be, because I will honestly tell you that I think the goal of most of this legislation is to have people that are considering purchasing property in a deed restricted community access to the information in the management certificate. So that means all of your governing documents. Does that mean it would allow owners to use artificial turf in front yards? Yeah, I mean, I do think that if you don't have a policy or a regulation that requires natural turf, then potentially you do have to allow artificial turf. I don't remember, there are some limitations in that statute, and I don't remember them off the top of my head, but if you're concerned about 100% artificial turf, reach out to your attorney about what you can do to limit that. House Bill 1812, does that mean amenity centers would be subject to the residential design guidelines? For example, roofs would have to be converted for metal, common area fencing, equipments. Nick, you're asking me some complicated questions. I'm happy to help you, but reach out to me. I don't remember what 1812 is about off the top of my head, so I'm not sure what you might be asking on that one. What about process servers? Can you deny them access in a community unless they're added to the owner's guest list since they are third party? Constables are always allowed. Yeah, I mean, it's a good question. We've always said if it's a constable or a sheriff that's serving process and you're gated, then you need to let them out. But I think there are some limitations on what could be defined as political speech or events or gatherings, and so that one probably needs to be fleshed out a little bit in terms of who we have to allow in. House Bill 3361, would this be the same during developer control or after transition? Sorry, y'all, I just don't remember the bill numbers, so I don't know the answer to that. Will an outline be provided of the potential updates? We're constantly pushing out information. Hopefully you're on our marketing emails. We have monthly newsletters that go out, a lot of them from now until probably the end, or actually the end of the year, not even the end of legislative session, i.e. September 1, when bills have an effective date. We're going to be putting out information about where bills are, what's been potentially or what will potentially be approved and signed by the governor, and how that might impact what you need to do. So just be on the lookout. Lots of other questions about reasonable fines. Yeah, I think we're kind of running out of time. I don't know what the answer is. There's no definitions provided in some of these about what's considered unreasonable or reasonable. So what max fine amount that would be considered reasonable, it's kind of going to be left to some guesswork and maybe a reliance on the association's legal counsel to kind of help you come up with a definition of what's considered reasonable. realtors don't check TREC filings now. How would this be different? It wouldn't. Sweet Dawn, I don't know. I mean, it's lovely to impose these burdens, but it is publicly accessible, that TREC filing website. So maybe homeowners can be, encouraged to visit the TREC website to really find information about the association, including all these policies and rules that we have to post. Something about a skeleton for a current holiday. Maybe I missed the question. Will there be another webinar? Yes, I'm sure there will be plenty more. Do you know if there's interest in modifying or clarifying or repealing Senate Bill 1588? Yeah, one of the ones I mentioned does modify perimeter fencing legislation, and it puts some limitations on it that we really, really like. Okay, so I'm gonna kind of end it there. It's 12:31. Thank y'all so much. We love it when we see so many people interested in our webinars, and especially the legislative ones. We would ask you to try and support TLAC and any lobbying efforts that you see to try and limit how these bills will impact the association industry. We're obviously very involved in the industry and want to make sure that none of these really kill all of the nice things and protections that associations provide to our communities. So again, thank you, and be on the lookout for our next webinars. We have a lot of information on our website. Feel free to peruse that, and this I'm sure will be available as well. Y'all enjoy the rest of your week and stay tuned. Thank you.